I've got an open container. Am I on a public road? Am I on a public road?
You don't have to be.
Does the statute say
it's a public place?
It's a public place, but am I driving on a public road?
You're in a public place.
I'm in a public place, but am I on a public road?
You're in a public place.
I'm in a public place, but on private property. It's publicly accessible private property.
You're not making sense, man.
I am making sense. It's publicly accessible private property.
Okay.
That means I'm not on a public road.
Okay.
So know the law and watch your fucking
know the
mouth.
law. Study the law and then argue with them. Okay.
I'm sorry?
You study the law and then you get to argue with officers. But first you gotta study the law.
Do you have any case law or anything that would support or interpret that provision of the Code of Criminal Procedure to give me any understanding of whether it should be a voluntary or involuntary? So your position, Mr. Hunt, is that if Mr. Atkins continued to commit crimes throughout his life, I would never be able to preside over any of those cases because I once in the past have represented the state against him.
Well, yes, Your Honor, just the plain language. Number one under Article 3001 says the judge has previously served as counsel for the state in a prosecution of the defendant. Number two is the judge was personally involved in said prosecution. In other words, in this prosecution. So it does address specifically this prosecution in one section. In another section, it says any prosecution. A prosecution means any prosecution, just plain language, Your Honor. So I think just the statute is under its plain language says that that grounds for recusal and disqualification of the sitting judge exist.
Before we start discussing the Texas Code of Criminal Procedure, we need to take a moment and cover some essential information up front. Knowledge of these persons and offense levels will make your understanding of the CCP much easier. First, the CCP refers to several members of the courtroom working group. Some of the terms the CCP uses are deceptively similar, and while the public might commonly use terms like police officer and peace officer interchangeably, the CCP does not. First, the CCP makes reference to magistrates. Next, the CCP will also refer to the clerk. This person is not to be confused with the court reporter who types out everything that is said during a hearing or trial. The clerk refers to the county or district clerk. This is the elected official or their deputy who keeps official records of judicial writs or legal documents such as subpoenas, search warrants, and affidavits. Next is the prosecutor. In some counties, the felony prosecutor is the district attorney, and the misdemeanor prosecutor is the county attorney. In other counties, the district attorney handles both felonies and misdemeanors. The defendant is a person accused of a crime. Here's a few other helpful notes. First, a reference to the court in the CCP is likely going to refer to the magistrate. Judge does not necessarily equal magistrate, and attorney for the state refers to the prosecutor. Finally, we need to talk about the penalty structure for offenses under Texas law. This is different for every state and the federal government. Texas has 3 levels of misdemeanors. The most serious is a Class A, followed by a Class B and a Class C, a fine-only offense. There are 5 levels of felonies. The most serious is a capital felony, followed by a felony of the first degree, felony of the second degree, felony of the third degree, and finally, the least serious felony, a state jail felony.
We shouldn't be mad at you about that. You ought to be mad at her about that.
Get married or
All right, this is cause number CR 2237, CR 2146, State versus Chad Edward Atkins. And let's see, we are set on, is it a motion to recuse today?
That's correct, Your Honor.
Go ahead, Mr. Hunt.
Your Honor, I filed a motion to recuse back on July 13th of this year based on information I received from a attorney who had previously represented Mr. Atkins. He said that during his representation in the previous case, that when you were DA, that you had actually made an offer in the case, which would thereby mean that you had contact in that prosecution, which would cause the necessity of you being recused as the sitting judge in this case. And so that's what we're asking, Your Honor.
All right. And State, have you looked into that matter, or has Mr. Hunt provided you any type of affidavit or anything to support that?
Your Honor, I have reviewed the record in both of Mr. Atkins' current open cases and his previous prosecution back in 2015. Your name does appear in the 2015 case in our system. However, it is my understanding of the rules that you are only recused if you have prior knowledge of these particular cases pending prosecution, which I indicted both of them subsequent to your leaving office as district attorney. I don't believe that you have any conflict with the particular cases on trial now. So the state respectfully disagrees with Mr. Hunt's motion, and I assume we will need to have a hearing before the administrative judge on this issue.
And Your Honor, I can quote the Code of Criminal Procedure, Title I, Chapter 30, Article 30.01 says that a reason or a cause for or grounds for recusal or disqualification of the sitting judge exists if, number one, the judge has previously served as counsel for the state in a prosecution of this defendant, not this prosecution.
Okay. I will need to contact my regional judge, and he will either appoint himself or another judge to conduct a hearing on the motion to recuse. Do you have any case law or anything that would support or interpret that provision of the Code of Criminal Procedure to give me any understanding of whether it should be a voluntary or involuntary? So your position, Mr. Hunt, is that if Mr. Atkins continued to commit crimes throughout his life, I would never be able to preside over any of those cases because I once in the past have represented the state against him.
Well, yes, Your Honor, just the plain language. Number one under Article 30.01 says the judge has previously served as counsel for the state in a prosecution of the defendant. Number two is the judge was personally involved in said prosecution. In other words, in this prosecution. So it does address specifically this prosecution in one section. In another section, it says any prosecution. A prosecution means any prosecution, just plain language, Your Honor. So I think just the statute is under its plain language says that that grounds for recusal and disqualification of the sitting judge exist.
Yeah, I've spent quite a bit of time reviewing the case law that interprets that section. I wanted to know if you've done the same.
I have not, Your Honor.
Okay, that's fine.
Seems pretty. I have not looked at the case law, but it seems fairly plain.
Judge, if I might, I would draw everyone's attention to Gamez v. State, which is 737 Southwest 2nd, 315, and I can send Mr. Hunt this site as well. Which again, I'm just looking at an annotation. I'm not presenting this as controlling at this point, although I think it may be. The annotation says the prohibition from residing over a case where a judge has previously been a lawyer for the state or defendant only applies when the judge has actually participated in the very case that is now before him or her. Again, that's an annotation. I'm not willing at this point, because I haven't actually read the case, to say that that is necessarily what it says, but that's an annotation. I would believe everyone would be well suited to look at that for authority. That's from 1987. So just if everyone wants to take a look at it, I think we should have a hearing, but just to guide everyone's research, I think we've discussed that in previous similar motions before this court.
And I would certainly need to look at that.
Absolutely. I'm not saying Mr. Hunt is wrong in any way, shape, or form. That seems to indicate a different reading, but everyone should do their research and we can reconvene on that later.
Okay, so what I'm going to do is I'm going to set it on the status on the motion to recuse. We'll set it for September 16th, and I will send notification to my regional judge that I am not voluntarily recusing in this case based on the stated grounds. Now, Mr. Hunt, you're not saying that I made an offer in the present cases. You're saying that I made an offer in a previous case that's not at bar.
That's correct. I believe it was a 2015 case, Judge. Correct.
Okay. So I'm not going to voluntarily recuse. So I will have the regional judge make an assignment and to hear that motion to recuse prior to the 16th. And then on the 16th, we'll discuss whether or not the ruling of the judge appointed to preside at that motion to recuse hearing.
And what was that date? I'm sorry again, Judge.
September 16th. Mm-hmm. All right, so we're adjourned in Mr. Atkins' case, and we will come back on the 16th to find out the ruling by the appointed judge.
Thank you, Judge. May I be excused?
Yes, sir.
Thank you. Mr.